If you just remain standing, we're going to have you administer another oath. Good morning, ladies and gentlemen. Welcome back. If you just remain standing, if you would, raise your right hand. The clerk is going to administer the oath to you as jurors in this case.
Do each of you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant, Michael David Dunn, and render a true verdict according to the law and the evidence, so help you God?
Yes.
All right, thank you, ladies and gentlemen. You can have a seat. And good morning, or actually good afternoon. Welcome back. Again, I want to thank you for your time and attention during the course of the last 3 days in our jury selection, and ask you to obviously continue to pay close attention to the matters that will ensue here this afternoon. You were selected actually yesterday and now have been sworn as the jury to try the case of the state of Florida versus Michael David Dunn. As you know from jury selection, this is a criminal case, and the defendant, Michael David Dunn, is charged with 5 separate offenses. The first count was first-degree murder. There are 3 counts of attempted first-degree murder, and the 5th count is shooting into an occupied dwelling. The elements of those offenses and the definitions that go along with it will be explained to you at the conclusion of the case. You should know it's your solemn responsibility to determine if the state has proven its accusations beyond a reasonable doubt against the defendant, Mr. Dunn. Your verdict must be based solely on the evidence or lack of evidence and on the law that I will instruct you on at the close of the case. The indictment that was talked about over the last several days, as you recall, is a charging document only. It is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and to apply the law that I instruct you on to those facts in order to reach a lawful verdict. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our justice system. Before we proceed, I would like to give you a little outline as to how the trial is conducted, so you'll have an understanding of what will come during the course of the afternoon and over the next several days. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement to you. The opening statement gives them an opportunity and a chance to tell you what evidence they believe will be presented during the course of the trial. What the lawyers say, however, is not evidence, and you are not to consider it as such. Evidence will come to you in the form of testimony from the witness stand, documents, photographs, things of that nature. Following the opening statements, witnesses will be called to the witness stand to testify under oath. They will be examined and cross-examined by the attorneys. Documents, as I said, and other exhibits, photographs, things of that nature may also be produced into evidence. After the evidence has been presented, the attorneys will then have an opportunity to make their final arguments to you. Following the final arguments of the attorneys, then I will instruct you on the law that applies to this particular case. After those instructions are given to you, you will be allowed to go back into the jury room to deliberate your verdict. As we've discussed on numerous occasions over the last several days, you should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the arguments of the attorneys, and the instructions on the law that I will give you at the conclusion of the case. Until that time, you should not discuss the case among yourselves. We've also talked about during the course of the trial, we'll take breaks. You'll have bailiffs with you during those breaks because of the sequestration issue. But during those breaks, you'll be allowed to do some other things. You should not discuss the case among yourselves or allow anyone to discuss the case with you or in your presence. If someone were to do something such as that, obviously, as we've discussed before, you would inform one of the bailiffs and they will tell me and bring it to my attention. We can handle the matter from there. The reason for that is, as again we've discussed on numerous occasions, is the case must be tried by you only upon the evidence presented here in the courtroom during the trial, in your presence, my presence, the attorneys, and the defendant, Mr. Dunn. You must not conduct any investigation on your own, as we've also discussed. This includes reading newspapers, watching television, or using a computer, a cell phone, the internet, any electronic device, or any means at all to get information related to this case or the people and places involved in the case. This applies whether you are in the courthouse or at the hotel during your sequestration. Obviously, you must not visit any of the places mentioned, and you should not look at the internet to try and observe anything along those lines. You must not have discussions of any sort with any friends or family members about the case or the people and places involved in the case. So even during visitation with family members, as we've discussed, you should not have any conversations with them about the case itself or the facts and circumstances surrounding it. We've talked a lot about this electronic age and the communication devices that are available to anyone. I need to stress to you again that you must not talk about this case, obviously face-to-face, with anyone, nor through any electronic device. You will not be able to use phones, computers, or other electronic devices to communicate unless it's under certain supervision. Do not send, accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet or website or such as that. You should also know, and we've discussed this somewhat over the last couple of days, that in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and procedure. It is their duty to make all objections that they feel are necessary and proper. When an objection is made, you should not speculate on the reason why it is made, nor should you speculate on what the answer to the question would have been had I allowed the question to be answered. The pads and paper in front of you, you'll see there, are for your ability to take notes if you wish. If you'd like to take notes during the course of the trial, you may do so. On the other hand, you do not have to. You're not required to. It's just there for your individual use if you so desire. Any notes that you take will be, as I said, for your personal use. You should not take them with you from the courtroom. When we are on breaks, we will gather them up and watch over them for you, and the same thing in the evenings. When you have finished, when the case is finished and you go back for deliberations, you'll be allowed to take the notes back there with you for you to review, again, for your own personal use. You should not share your notes with any of the other jurors, and you should just use them for your use to help your own recollection of the testimony and the evidence. Also, let me caution you about getting too involved with note-taking itself. Different people take notes in different ways. Some people take notes almost verbatim, others are shorter about it. Do not let the note-taking distract you from what's going on. When the witnesses are called to the witness stand, the attorneys will be asking questions. When they ask a question and get an answer, they're not looking over to see if you have finished taking notes. They're going to continue on in this process. So be careful about that. Sometimes you're writing something down because you believe it to be very important. You may miss the next question and or the next answer. It may not have been particularly important, but it may have been. So just I caution you about that and ask you to be careful when you're taking the notes. Whether or not you take notes, you should rely ultimately on your memory of the evidence, the testimony that has come before you. You should not be unduly influenced by the notes of any other juror. Again, the notes are for your particular use. So if you were to get into the jury room and collectively as a group decide somebody was the greatest note taker you've ever seen, you cannot rely on their notes as a group. The notes are just for yourself. And as I said, your greatest tool is your memory of the evidence, but you can use the notes to help you with that. So with that said, we're ready to begin with the opening statements. We'll hear first from Mr. Guy on behalf of the state. Mr. Guy?
Thank you, Your Honor. May it please the court?
Yes, sir.
Counsel, good afternoon. As they had been so many times before, the two best friends were side by side. Jordan Davis and Leland Brunson, sitting in the back seat of a friend's SUV in the middle of a holiday weekend of mall hopping and girl shopping. But this moment was unlike any other the two best friends had ever spent. Bullets, 9 of them, had come crashing through the glass and metal surrounding them. Some of the bullets had whizzed by their heads, in the heads of 2 other teenagers who were in the car. Some of the bullets had been stopped by the metal in the doors. But some of the bullets were unaccounted for. And so 4 terrified teenagers began an ominous roll call. Tommy, Tevin, Leland, Jordan. Everybody responded to the sound of their name, except Jordan Davis. He was lying in the back seat with his head in Leland Brunson's lap. Unbeknownst to any of them, 3 of those bullets had found their target. One of them had entered his right leg. One of them had entered his left leg. And one of them had entered his right side, tore through his liver, passed through both of his lungs, and shredded his aorta. And then the blood that for 17 years had run so naturally through Jordan Davis's veins and arteries was pouring out of them. And so the two best friends were side by side for the last time. Jordan Davis, gasping for air, was taking his last breaths of life. And Leland Brunson, who was cradling his dying friend, was taking his last breaths of innocence. And at that exact moment, the man who, fueled by anger and intent, had fired 10 times, 10, into a car of unarmed teenagers, was driving away, as though nothing had happened. Michael David Dunn pointed a semi-automatic pistol at 4 unarmed kids from a distance much closer than you and I, and then drove off. He didn't call the police. He went to his hotel with his girlfriend, and he called a pizza delivery man and ordered a pizza. He took his little dog for a walk outside the hotel, turned on a movie, and made himself a big, tall rum and coke. And not long after, an emergency doctor at Shands Hospital pronounced Jordan Davis dead. That defendant put his head on his hotel pillow and went to sleep. But ladies and gentlemen, as you are about to learn, there are some things that defendant will never, ever be able to run from. The physical evidence, the bullet trajectory through the car and through Jordan Davis's body, that will prove to you beyond any doubt that when that defendant opened fire, Jordan Davis was sitting in his car seat with the door closed, with nothing in his hands. And he was leaning over, away from the gunfire, toward Leland Brunson. Secondly, the words from that defendant's own mouth at the time of the shooting, words of hate, words of intent, words that he can't now take back. And most importantly, the memories. The wretched, indelible memories of the 3 boys who survived. And a host of witnesses at a gas station, including his own girlfriend, who he made witnesses to a homicide. The date was November 23rd, 2012, the day after Thanksgiving. Everybody knows it now as Black Friday. And 17-year-old Jordan Davis got together with his best friend, 17-year-old Leland Brunson, both of them students at Wilson High School. And as teenage boys are wont to do, they called two other friends to go to the mall to look for girls. So they called 17-year-old Tevin Thompson, a student at Atlantic Coast High, and 19-year-old Tommy Storms. And the four teenagers jumped into Tommy Storms' red Dodge Durango and went to the town center and struck out. The only person of note they ran into was Jordan Davis's on-again, off-again girlfriend, Aaliyah Harris. And then they climbed back into the car and headed for another mall, the Avenues Mall. But they stopped. They stopped at a gate gas station at the intersection of Southside Boulevard and Bay Meadows Road. And Tommy Storms pulled in to a parking space right in front of the door, facing the store. Tommy Storms got out to go inside to get some cigarettes for himself and some gum for the other boys. And Tevin Thompson and Leland Brunson and Jordan Davis sat in the car listening to music. Their music. Loud music. Rap music. And then into their lives and into the parking space right beside them pulled the defendant. And after his girlfriend got into the store, he turned his attention to the boys. But before his girlfriend got out of the car, he turned to her and said, "I hate that thug music that was rattling his rearview mirror." And his girlfriend just looked at him and said, "I know," and went in the store. And rather than go into the store himself or move his car, the defendant chose to roll down his window. He was right next to Tevin Thompson. Tevin Thompson was in the front passenger seat. The defendant was in the driver's seat of his car. And he looked at him and said, "Hey, can you turn that down? I can't hear myself think." So Tevin Thompson turned the music down. But Jordan Davis, who was sitting behind Tevin Thompson in the rear passenger seat, didn't want to be told what to listen to, or at what volume to listen to it at. So he said, "F him, turn it up." And he didn't say F, he said the word. And he didn't say him, he said the N-word. But he said, "Turn it up." So Tevin Thompson turned the music back up. And then Jordan Davis and the defendant started jawing at each other. Jordan Davis is 5 feet 11 inches tall, 145 pounds. The defendant is 6'4" and well over 200. But they exchanged F-bombs back and forth. And at about the time Tommy Storms got back in the car, the defendant rolled down his window again and said, "Are you talking to me?" And Jordan Davis looked at him and said, "Yeah, I'm talking to you." And then the defendant said, "You're not going to talk to me like that." And in the same motion, he reached in his glove box and grabbed his pistol. And he pulled the slide back to chamber a live round. And with two hands, he pointed out his window back at Jordan Davis's door and pulled the trigger 3 times. Every one of those shots in a nice, tight little circle went through the door and into Jordan Davis's body. Tommy Storms, the driver, as you can imagine, was terrified and put the car in reverse and backed up. The defendant didn't stop. He kept focused and aimed on the car, and he pulled the trigger 4 more times. And you'll see the bullet holes in Tevin Thompson's door, one after the other. 3. The 4th shot missed. And then Tommy Storms backed all the way up and pulled off as fast as he could into an adjacent parking lot. But the defendant didn't stop. Instead, he opened his driver's door and put his legs out and took aim again and pulled the trigger 3 more times. Every one of those shots hit the car. 2 of them in the back where the taillight is, 1 of them in a rear window that crisscrossed the car, passing between all 4 of their heads. It came in the back right window and ended up in that little sun visor above Tommy Storms' head. Tommy Storms got out of the parking lot and stopped the car to see what was wrong, to see who and what had been hit. And they started that roll call that Jordan Davis couldn't respond to. And Tevin Thompson and Tommy Storms got out and they opened the back doors and they saw Jordan Davis and they saw Leland Brunson and they realized what had happened. And they jumped back in the car and they didn't park or turn it around where there was lighting and had already pulled off with his girlfriend, and the 4 teenagers were back in the gate parking lot. And people did come and pull Jordan Davis out of the car and put him on the ground and tried in vain and you will be witnesses then. And you'll hear from each of the 3 boys who lived in the car. Leland Brunson, a wisp of a kid, maybe 150 pounds, maybe. And Tevin Thompson, big guy, round face, smiles a lot. And they'll tell you about the interaction between Jordan Davis and the defendant. That Jordan Davis was upset, no doubt. He was cussing, no doubt. He raised his voice. But he never threatened the defendant. He disrespected the defendant. And Tommy Storms, the driver, who came back to the car and saw the defendant pull his gun. And you'll learn that Jordan Davis, the only thing he had on his person was a cell phone and a pocket knife. And both of those things were in his pockets when he was shot and killed. And when they cut his clothes off him, his little pocket knife and his cell phone were in his pocket. But you won't just have the people in the car. This happened at a gas station before 8 p.m. on Black Friday on the South Side. You'll hear from people like Stephen Smith, a contractor who stopped there to get something to drink, and who walked out the front door of the store. The defendant's car was the first spot next to the door, and he was stopped by what he heard the defendant say, "You're not going to talk to me like that." And he looked, maybe 10 feet to his right, and saw the defendant pull that gun and aim it out the door at point-blank range at the car next to him and pull the trigger. And saw the red dot string go back up and the defendant keep firing. And saw the dot string go pull off and the defendant keep firing. You'll hear from people like Andrew Williams, who was on the street, and when he heard the shots, he pulled into the gas station. And he pulled Jordan Davis out of the car because he had a medical background. And he put his hands into Jordan Davis's chest in vain. You'll hear from people like Sean Atkins, who had the wherewithal to remember the tag number of the defendant's car before it pulled off. That was given to the police. People like Samantha Ickes, who pulled in just before the boys pulled back in and saw the holes in the car and saw the panic on their faces and called 911. You'll hear from people like Christopher and Alyssa LeBlanc, a brother and sister who had had dinner at the Loop restaurant, which is in the next plaza. They were walking back to their car when they heard the gunshots, and they saw the red Dodge Durango coming towards them and stopped suddenly. And they saw two black males, Tommy Storms and Tevin Thompson, get out of the car and look in the back. They didn't know what they were looking at, that it was Jordan Davis. They just saw him get out of the car. They didn't see him leave the car, the area of the car. They didn't put anything in the car. They didn't take anything out of the car. They just looked in the back. And then they got back in and put it in reverse. And the LeBlancs got in their car and they called 911. But you won't just have witness testimony, you will have forensic evidence. A bone-chilling audio tape. Because the Gates store has surveillance, video surveillance on the inside of the store only. And so you'll see Tommy Storms, tall guy, real skin, got dreadlocks, maybe down to his shoulders, go in and buy a pack of cigarettes and some gum. And you'll see the defendant's girlfriend, Rhonda Rauer, put a bottle of wine on the counter and a bag of potato chips. And then all of a sudden, out of nowhere, 3 remarkably loud bangs. The shots that killed Jordan Davis. And then a pause. 4 more shots. And then the long pause, where the boys pulled off and he opened his door. 3 more shots, all of which hit the car. And you'll have the car itself. The red Dodge Durango was at the scene, of course, and it was secured. And you'll see through the photographs that when the bullets went through Jordan Davis's closed door, it blew pieces of the inside of the door into the car, big pieces of plastic and rubber, into the car, because the door was closed. And they searched the car. There was a basketball in the back. There were basketball shoes. There were clothes. There were the big 12-inch speakers. There were cups on the floor. There were no weapons. And he yelled at her again, "Get in the car." And she did. And they pulled off. North on South Side Boulevard, maybe 3 miles to the Sheraton Hotel. They had cell phones, but the defendant didn't call 911. Didn't drive to a police substation. He drove to the parking lot. He put his gun back in the glove box, and he walked inside. He didn't tell anybody at the front desk. He just went upstairs. And he called a pizza delivery service to get a pizza. And he got his little dog, and he went down, he took him for a walk, and they turned on a movie, and he poured a big, tall drink, rum and coke. And then he went to sleep. But in the morning, Rhonda Rauer turned on the news, and there was a story of a shooting south side. And a 17-year-old boy had been killed. And she told the defendant about the news story. And then they packed their bags and went home to Brevard County, 2.5 hours away. And you'll learn that they had been at a wedding before stopping at the store, the defendant's son's wedding. And they skipped their plans for Saturday night in St. Augustine and drove back to Brevard County and unpacked their bags and went inside. But through the night, while the defendant was sleeping, the detectives were working. Remember the guy who wrote down the tag number, Sean Atkins? They ran the tag. It came back to the defendant. And in the middle of the night, they put together photo spreads with the defendant's picture, and they showed them to the three boys. Tevin Thompson, who was right next to the defendant, recognized, identified the defendant. That's the guy who shot Russ. And he signed his name. And they got an arrest warrant. And they went to Brevard County the next morning and arrested the defendant, who had not a mark, a scratch on him. And they seized his car, and in the glove box was a Taurus 9mm pistol with 10 rounds missing, and a magazine underneath it, another full magazine. And they searched that car. There was a shell casing on the front floorboard, right by the defendant's right foot. There were 4 shell casings in that little trough between the windshield and the hood that the expelled casings had been caught in, that matched the 5 casings at the scene. And you'll hear from a ballistics expert, Maria Pagan, with the Florida Department of Law Enforcement. And she will tell you exactly how the defendant's gun operates, what the trigger pull is. Fancy term. It's just the amount of force it takes to pull a trigger. And she'll tell you that to expel a single bullet, you have to pull the trigger 1 time. To fire 10 times, the person has to pull it 10 times. And she'll show you how the gun works. But ladies and gentlemen, you're also going to learn in this trial, as Ms. Corey discussed with you yesterday, real trials are not like TV. And the witnesses are not well-spoken actors and actresses. For example, Sean Atkins, the guy who was standing there, who had the insight to write down the tag number, he's in prison now. Since November of 2012, he's been arrested, prosecuted, sentenced to prison. Tommy Storms, the 19-year-old driver of the car, was on probation at the time, felony probation, and he had a curfew. He was supposed to be home at 7 p.m. He was violating his curfew when the gunshots went off at 7:38. And when you listen to the witness's testimony, you'll hear inconsistencies, real life inconsistencies, the way it happens in everyday life. And finally, ladies and gentlemen, you'll hear from Dr. Stacy Simons, the medical examiner who performed an autopsy on Jordan Davis's body. Critical testimony. And she will take you through and show you the path of each bullet. How 2 bullets entered the backs of his legs around his groin, one of which lodged in his left hip. And you'll see an x-ray of the projectile, and you'll see the projectile itself. And the 3rd bullet that went into his right side about midway up and passed through his liver and his lungs and his aorta And you'll see that the path of the bullet is like this because Jordan Davis was like this when he was shot and killed, leaning away from the defendant. And you'll see an x-ray of that bullet lodged in his chest. And ladies and gentlemen, at the end of this trial, Judge Healy will read to you the law that applies to all of us, the laws that apply to each of us. And we are confident that after you hear the evidence in all of it, that you will know beyond any doubt in your head, in your heart, in your gut, that when that defendant pointed that pistol at the car full of unarmed teenagers and started and continued to pull the trigger, he was guilty of shooting into an occupied vehicle, guilty of 3 counts of attempted murder, and guilty of the first-degree murder of Jordan Davis. Thank you for your time. Thank you, sir.
Thank you, Mr. Guy. Mr. Stroller.
Thank you, Your Honor. May it please the court.
Yes, sir.
Opposing counsels. Members of the jury. What did we talk about in jury selection? Can't use sympathy. Can't use anger. Can't use bias or prejudice. And no matter how soft Mr. Guy wants to talk and how slow he wants to tell you it, that's not the evidence. What he says is not evidence. What you hear from this witness stand, what you see with your own eyes, with the state's witnesses, is evidence. And as Mr. Guy put it, real inconsistencies is real life every day. Well, every day, people aren't on a trial for crimes they didn't commit. And we talked about you can look at something and see 2 separate things looking at the same picture. And Mr. Guy told you his version. Mr. Guy told you what he believes the evidence is going to show. And again, he could say it as slowly and softly as he wants. But the judge is going to instruct you the law is you can't use sympathy, empathy, anger, bias, or prejudice. Now, what did you hear Mr. Guy say? The first person to get upset, and the evidence is going to show that the only person that cursed was Jordan Davis. And his words to Michael Dunn were, "I'm going to fucking kill you. I should kill you right now." See, that's what Mr. Guy didn't tell you the facts are going to come out prior to any gunshots being fired. All because Michael Dunn asked for a common courtesy. And the gentleman in that car will admit to you on that stand under oath that the music was so loud, it was rattling the windows, the mirrors. They couldn't even hear themselves talk, sitting in the same vehicle. But yet they want you to believe that this man, so angrily coming back from his son's wedding, said, "Turn down the music, I can't hear myself think." And Mr. Thompson, the gentleman in the front passenger seat, we call shotgun, will tell you he could only see Mr. Dunn mouth those words. Couldn't even hear him. And Kevin Thompson lowered it. And what you're going to hear is the next thing my client says, Michael Dunn, was, "Thank you." And he puts his window back up. And then as Mr. Guy says it, the first words Jordan Davis says, "Fuck that nigger, turn it back up." That didn't come from Michael Dunn. Not a single remark, not a single curse word came from Mr. Dunn. Matter of fact, the gentleman in the car will tell you that they never heard Michael Dunn curse. He never raised his voice. And he never yelled at them. And all three men in that car will tell you that the music was so loud, they don't even know if Jordan Davis actually threatened Michael Dunn. But what you're going to find out through the evidence is law enforcement didn't care. The state attorney's office didn't care. Because the evidence is going to show that they took those three men to the homicide office to take their statement. They put them in a room, had video, had audio. They didn't use it. The homicide detectives are going to tell you that's not protocol. I've got to go to my assistant chief and my lieutenant. We don't video and audio people who are allegedly a victim of a crime. Okay? The homicide detectives are going to tell you that they even have tape recorders. They could use it. None of them did. Matter of fact, the lead homicide detective, Detective Musser, was so unprepared, he didn't even bring his laptop to the crime scene when he was summoned to go from his house. He couldn't even watch the surveillance video. He didn't watch the surveillance video. He had his fellow officer go get it. Not even a homicide detective. He didn't even know what was on it till days later. You're going to find out that Detective Musser asked another homicide detective, all right, you go get the video. I've got other stuff to do. Their surveillance video of the shooting was so unimportant to Detective Musser, he gave it to somebody else to delegate with no description of what he wanted. Now what you're going to find out about that surveillance video is there's video and there's audio. You can hear what's going on. You can see what's going on. And the one thing Mr. Guy didn't tell you the evidence is going to show, that once the crime scene was what they called secure, all of the witnesses from outside were brought into a little area inside that gate gas station, right underneath the cameras, right where there's video and audio. And some witnesses, depending on who the state calls, will tell you, yeah, people talked. Some people said the officers told us not to. Some of the witnesses said they didn't. Some said they were standing inside. Some said the officers were only outside. But if you want to get through those inconsistencies, all the detective had to do was look at the video, realize it's got audio, and just ask the gate gas station, hey, give me an extra hour or so where my witnesses are in there. Let's ensure that witnesses aren't talking to each other. And they don't. For days. And what you're going to find out is, on the video, on the surveillance video, you're going to see a witness, one of the gate employees, start immediately talking to the next customer in line about what just happened and what she saw. You're going to see her start talking to another gate employee about what just happened and what she saw. And the video goes off 10 minutes after it happens. Not because Michael Dunn said stop the video, because the police didn't care enough to preserve what the witnesses may have said on video. And we'd have audio. And the way Mr. Guy presents his evidence was nice and slow, methodical, almost premeditated. None of the evidence presented will show any of that. And like he said, beyond any doubt, you'll see Tommy Storms walk out. He was the driver of the car. This is the man, it's his SUV, pumping the music, and that's okay. But he had no idea what happened. He gets into his truck, and he doesn't see Mr. Dunn in person. He has to walk, literally, this close to Michael Dunn. Because Michael Dunn is the first car out the door. And guess where the red SUV is? It's right next to Mr. Dunn's car. And the state's witnesses will tell you that it was front to front, window to window. So Mr. Thompson is sitting right next to Mr. Dunn. And Jordan Davis would be behind him. Mr. Storms would have to walk right in front of Mr. Dunn, right in front of the red SUV and never claimed to have heard yelling, cursing, anything by Mr. Dunn. Not even a visible sign of aggression or anger by Michael Dunn. But Mr. Guy didn't tell you that in opening statement. My next point is, when you hear the witnesses testify, don't just keep an open mind on direct examination. Listen for the cross-examination. We talked about it in jury selection. I'm going to ask some real hard questions. And there will be inconsistencies. And there will be some questions they can't answer. But Mr. Guy tells you, beyond all doubt, you're going to find out that not only does the SUV speed away, they drive over 100 yards into another plaza filled with cars. There's two people, allegedly 10, 15 feet away from them, Chris LeBlanc and Alyssa LeBlanc. Mr. Storms gets out of the car, opens his back door. The 911 call even says from Chris LeBlanc, it looks like they're stashing something. Those are his exact words. Mr. Thompson gets out of his door, opens the back door. So now you've got two men from the SUV fumbling in the back, looking like they're stashing something. Not doing the roll call, not screaming, "Oh my God, our friend's been shot, call 911. What does Tommy Storms do? Calls 911 and hangs up. What does Tevin Thompson do? Nothing. What does Leland Brunson do? Who's cradling his best friend dying? Nothing. Chris and Alyssa LeBlanc, the brother and sister, will tell you that nobody was screaming, nobody was panicking, and nobody was yelling. And here's the key. They're going to tell you that one of those men were on the cell phone talking. But none of the men will be able to tell you who they recall talking to. Yet Mr. Guy tells you that evidence shows they go back for help at a gas station with no medical personnel, with cell phones where they could call 911, in a lit plaza with people and cars. Now you're going to hear a statement that Miss Wolfson gives. And if they play the audio, you'll hear Miss Wolfson lead the entire time. You'll see her lead the witnesses the entire time of what answer she wants. And you're going to hear Alyssa LeBlanc say, well, I didn't see him get rid of anything, right? Because now they're trying to stash a weapon. They're getting it out of the vehicle. They could easily throw it underneath the car. They could be on the phone with their friend. Man, you got to get up here. Just got shot at. This is where it's at. Come get it. Click. That call's more important than 911 to the men in the car. Chris LeBlanc will tell you, oh yeah, I didn't see him get rid of anything either. They really never left the truck. But see if he can tell you, or Miss LeBlanc can tell you, that once they get out of the vehicle and the front doors are open, the back doors are open, you lose sight of them. They have no idea what Tommy Storms and Tevin Thompson are doing in the back of that car, because now at least Mr. Thompson's completely out of sight. They then reverse back. They still don't call 911. They pull into a parking spot. Mr. Guy said Samantha Ickes, very important witness. After a shootout, they're panicked. Their friend is cradled, taking his last breath. You would think that car would fly back in, pull into a spot. No. Miss Ickes will tell you the red SUV pulled up right next to her, calmly, slowly. Nobody said anything from the red SUV. She looked over and saw bullet holes. And Miss Ickes asked, is everything okay? She'll tell you, I've never seen anything like that. I didn't know what to do. I was in shock. Because she wasn't there for the shooting. She pulled in after. The red SUV was gone for so long, over 100 yards away in another parking lot, that people could pull into the plaza, talk on the phone, go to get gas, and had no idea a shooting just occurred. And that is when one of the boys in the car says, "Could you call 911?" For the first time. And not one witness can tell you where Tommy Storms went when he got out of the truck. Not one witness can tell you where Tevin Thompson went when he got out of the truck. The only person we know who stayed in the truck was Leland. Now they tell you a witness showed up who had medical training, who gave CPR. You're going to hear that there's officers standing at the red SUV, and they let a civilian help pull Jordan Davis out of the car and administer CPR. He was a lifeguard at 16 years old and had never done CPR in his life. And that's who the Jacksonville Sheriff's Office allowed to work on Jordan Davis and called it medical background experience. A guy who was a lifeguard when he was a kid. Now, I don't fault that gentleman for trying. But if you look at the evidence and what the Sheriff's Office did and did not do, it's unmistakable. They're not everyday inconsistencies. They don't take sworn statements from the gentleman in the car. They don't even put him on video. They don't record him. But you know who they did record that night? Sean Atkins. In the same room Tommy Storms, Leland Brunson, and Tevin Thompson were, they record a statement from a guy who saw nothing. And he'll admit, he doesn't know why it happened. He never heard anything. Matter of fact, he says that my client pulled up before the red Durango, which nobody will say. But they want you to believe he's so reliable, you got to listen to him. The one who's now a 10-time convicted felon. And what Mr. Guy didn't tell you is that he even asked the state if he could get time off his sentence for testifying on behalf of the state of Florida. If he could stay in Jacksonville just a little bit longer and not go back to prison, that would be great. The evidence will show that there was motive, bias on the part of the men in the vehicle. Matter of fact, what Mr. Guy didn't tell you is Leland Brunson admitted that Jordan Davis tried to get out of the car. Leland Brunson even said Jordan Davis grabbed that rear handle of the Durango to get out. But you know what happened after that? 4 days later, the sheriff's office goes and checks the Durango. Why would they check the Durango? Because 4 days later, every man in that car said, "Oh, the child safety locks were on. Jordan Davis couldn't get out." And if you don't know what the child lock is, you pop it on, it's a little lever, and you cannot open the car from the inside. Now, why would they all say that? Leland Brunson had been in that truck one other time. Jordan Davis had been in that truck one other time. They knew Tommy Storms for less than 30 days. And we're driving around town with them. And as Mr. Guy said, the best friend's driving around the back of the SUV. Well, not Mr. Storms' SUV. They didn't even know him. They had just met him. So how would they know the child safety locks were on unless they talked to each other and tried to get their stories together? And Mr. Ron Davis, the father of Jordan Davis, will even tell you that within a day or two after this, they were at his house. And that they were still so off on their stories, he believed they were still in shock. Because none of the three men's stories made sense or were accurate. Now, what do you think the evidence technicians found when they went to that SUV and looked at the back door? Where do you think those child locks were? They were off. Off. Meaning when Leland Brunson actually admitted that Jordan Davis tried to get out of the car, he was trying to protect his dead friend from the truth. That Jordan Davis threatened Michael Dunn. You're dead, bitch. This is going down now. With a shotgun barrel sticking out of the window. Or a lead pipe. Whatever it was, it's a deadly weapon. And you'll hear the law from Judge Healy. And you'll rule on that law. And you'll see the evidence. They can try to show you the forensics. But what they can't do is match the trajectory of Jordan Davis getting out of the car. And it wasn't, as Mr. Guy said, Mr. Davis was leaning over. You know why? You know why we know that's not true, and you'll find out? Because Leland Brunson will testify that as they saw Mr. Dunn reach for the gun, everybody in the vehicle ducked. Tommy Storms ducked. Tevin Thompson ducked. Leland Brunson ducked. You know who didn't duck? Jordan Davis. You know why he didn't duck? Because he was getting out of the car with a weapon. After telling Michael Dunn, you're dead, bitch. This is going down now. You have 4 men against 1. But you know what Jordan Davis didn't realize? The other man was armed. And there's an expression, God all made men equal, or God didn't make all men equal, Colt did. And Colt is a firearm. And that's what happened. And it's tragic. We're not here to change the laws. We're not here to say anybody deserved to lose their life. But under the law, it's justified. And Michael Dunn, after the facts of this case and the law, had every right under the law to not be a victim. To be judged by 12 rather than carried by 6. That's law, and that's justified in the great state of Florida. And you're going to see the inconsistencies. You're going to hear it for yourself. Listen to cross-examination. Listen to what comes out. That the music is so loud, the men can't even hear Jordan Davis yelling at Michael Dunn. But the officers didn't want to put that in their reports because it wouldn't look good. They didn't want to record the men in the truck because if they had to change their answers like, oh, the child locks were on, we'd have it. Right? A video lie doesn't lie. An audio doesn't lie on that video. So, of course, why would they ask up the ranks to record these men's statements? Because then they can't change it. Just like they did to his fiancée, Rhonda Rower. They took her sworn testimony, put it on video and audio. Why? She can't change it. Not that she will. The homicide detectives talked to these young men multiple times and never recorded it. Not once. And they had the ability to. And you get to ask yourself why. Every gentleman in that car is going to say he didn't have a weapon, but we know that he did. And Mr. Guy calls it a pocket knife. But when you see it, it's a tactical knife. It's not a Swiss Army knife with a toothpick and a scissor. It's not like when you were a kid, the little brown ones you'd whittle with wood to make little tips on sticks. It's a 4-inch blade with black grooves to put your fingers on when it's open. It is a knife specifically made for self-defense. And not one person in the car either knew that Jordan Davis had that weapon, or they lied to the police about it and didn't want to tell them he had that weapon. There was ample time to get rid of a firearm or pipe or anything of a deadly weapon because they're 100 yards away in a dark parking lot. And with that, wait till you hear when the police went to check. They talked to Mr. Dunn the next day. Heard what he had to say the day after. Right? Next day, next morning. 4 days. 4 days, not an officer checks the parking lot. They don't check the dumpsters. They don't check the roofs. They don't check the bushes. Not even the night. And what you're going to find out is that entire parking lot was exposed to the public. They know that the SUV left the scene because Officer Fortuno was across the street arresting somebody for a DUI. He's the one that called it out and saw the high-profile Durango fleeing the scene. And even though Officer Fortuno, the first officer on scene, knew the SUV left, called it out on everyone's microphone, not one officer checked the parking lot, checked the bushes, checked the roofs, checked the dumpsters, checked the lakes, nothing. That parking lot wasn't even secure. And how do we know that? Because news channels were already parked there. Tommy Storn's uncle and mother, or aunt, who's now his guardian, was in that parking lot. The boys made phone calls and people came to that parking lot where they left to. There's opportunity to hide that weapon. So keep your mind open and your ears open. Again, what I say and what Mr. Guy say are not evidence. But you notice much of what I'm saying didn't come out of Mr. Guy's opening statement. Now, Mr. Guy also says that all of these men are now in shock. And his exact words in opening, like everyone else, they were in shock. But why does that standard of fairness not apply to Michael Dunn? He just had somebody threaten his life, display a weapon, try to exit a vehicle and say, "This shit's going down now, bitch." And for the first time in his life, he has to use a firearm to defend himself. And you'll find out he was trained. You'll find out he had a carry concealed weapons permit. And you'll find out he owned that firearm for years and never in his life had to use it until that night. And yet, it's okay for the state's witnesses to be in shock, but not Michael Dunn and not Rhonda Rauer. And you're going to hear from Rhonda Rauer. She's the one that asked for the pizza. She was nervous. She was meeting Mr. Dunn's family for the first time. She didn't eat much at the wedding. She had just been through what everyone will agree to is a traumatic, tragic experience. No one will dispute that. She got the information for the pizza. She wanted to try to put food in her stomach. She's the one that watched the movie to put herself to sleep. And you're going to hear from her take that stand. And you're going to hear that this evening was so traumatic for her that she sought mental health counseling and is now on prescription medication. And you're going to hear her tell you that they did make a drink back at the hotel room, that they were shaking, that she had never seen Michael so upset, not angry, not violent, not abusive. In fact, Rhonda Rauer is going to tell you that he was so attentive to make sure she was okay. She had to step outside the room to get air because he wouldn't stop touching her, talking to her, making sure she's okay. And she said, "I've never seen him in that state before." She's never been in that state before. And they didn't go walk their dog. They had a small puppy that they brought to the hotel. The only reason they stayed at that hotel was it was pet friendly. Matter of fact, Michael Dunn left his son's wedding early so they could go get the puppy, so that it could pee or poop or go outside. Mr. Dunn didn't put the dog on a leash. He didn't walk it around the neighborhood. There's a spot right downstairs from the elevator that's actually on cement. And Miss Rauer's going to tell you, you go right around the corner to the back of the hotel, the dogs go, you pick it up, and you go right back up, and that's what Michael Dunn did. But further, the reason they left Jackson, Rhonda Rauer will tell you, as she told the detectives just the next day, and a couple days after that, she was the one that panicked so much that she begged Michael, we have to go home right now. We have to go back to Satellite Beach right now. And Miss Rhonda's not really familiar with guns. She didn't know the law of self-defense. She thought you fire a gun, somebody dies, you go to jail. And Miss Rauer was petrified. And she told the homicide detectives, it wasn't Michael. It was me. I made him take me home. I wanted to situate my things, get the dog together, because she believed she was going to jail. And if the state plays you her video, you'll even hear her say that to Detective Musser, and he even says, no, you're okay. Even well after the incident, she was still that panicked. And yet, Mr. Guy didn't bring that up on opening statement. So listen to that witness stand. Don't just listen to one side, listen to both. You make that decision. You're the instant replay in this case. And for Michael Dunn, you're all he has. Because nobody in law enforcement cared what he had to say. Nobody in law enforcement wanted to hear what he had to say. They just wanted to give you their own version of what happened. And you're going to hear that on the night this happened, Miss Wolfson was present. You're going to hear from the homicide detectives that Miss Wolfson has the ultimate authority to record witnesses. That Miss Wolfson in the state attorney's office trumps their procedure, their policy, their assistant chief. And you're going to see Miss Wolfson take one sworn statement that night. One video. Sean Atkins, a convicted felon who wanted benefit for his testimony, who saw nothing. And on the night he talked to police, he even said it looked like Michael Dunn was shooting at the ground to scare the car off. Now, my final points on opening with the evidence. You're going to hear from their experts. Their experts. People that work with law enforcement, including the medical examiner. And listen very closely. Listen to what she testifies to. Because her testimony has got to be consistent with the evidence. Not just the organs that she worked on. She's a doctor. She's a medical doctor that works for autopsies for the state attorney's office when it comes to homicides. You're going to find out that this was a second career for her. She was a graphic designer, and then at some point in her life decided, I'm interested in forensics. I'm going to go to a medical school specifically to become a medical examiner. And based on what Mr. Guy said, this doctor, with her expert opinion, is going to tell you that Mr. Davis was sitting down and now leaning. And that's why the trajectory the way that it was. Doesn't make sense. Why? Because Leland Brunson already testified before she formed her opinion that everybody ducked except Jordan Davis. He even tried to grab Jordan Davis and pull him down. And Leland Brunson's going to testify that Mr. Davis was allegedly sitting down, feet forward, left arm up on the back chair, right arm up, making hand gestures, yelling at Michael Dunn when the shots went off. And that everybody ducked but him. Now, if the entrance came from the side and went straight through, we already know Mr. Dunn's on a vertical angle. Mr. Dunn is not next to the back passenger door. Mr. Dunn is at a lowered Volkswagen car to a high-profile SUV. So unless the state can prove the JFK magic bullet theory, Dr. Simon's testimony won't match up to their own witnesses. And 3 bullets did go through. You're going to hear the audio. It wasn't slow and methodical. There was no premeditated design. You're going to hear bang, 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 bang. That quick. And that's as Mr. Davis was getting out of the car to try to kill or hurt with a deadly weapon Michael Dunn. They back out behind him, right behind Mr. Dunn's car. Mr. Dunn puts his gun out the window with his door open, and as they drive away, doesn't want fire back, because now they've got a perfect shot at the back of Mr. Dunn's head. And he puts 2 bullets low into the car, and as you can see, the bullets go up. And you'll hear it. Bang, bang, bang. Quick. No long pause. And the evidence will not show that Mr. Dunn went after that vehicle, tried to chase them down, tried to follow them to shoot them. He had extra rounds in the gun. When they found the gun, the evidence technicians in Brevard County are going to tell you it's a 15-round clip. 10 shots were fired. 5 are still in the gun. Well, what does that tell you if you know about weapons? A bullet was never chambered in Michael Dunn's gun. He had to actually pull the slide to fire the first round. So Mr. Dunn wasn't lying in wait, waiting to shoot somebody listening to thug music. He didn't have a bullet in the chamber ready to shoot someone at a moment's notice. It was a safely loaded firearm 2 steps away from his vehicle, in a holster, in a glove box. And he never reached for it, not even when my client first sees the weapon. It's not until Jordan Davis gets out of the car with that weapon and says, "You're dead, bitch. This is going down now." That's when he reaches for the gun. You're also going to find out that there was an extra clip in his glove box. So not only did Michael Dunn have 5 more bullets ready to be fired at a moment's notice, and he doesn't unload the clip to the men in the car. He doesn't chase them down. He grabs his fiancée and gets back to the safety of his hotel. And in a panic, for the first time in his life, has no idea what to do. Rhonda Rauer has no idea what to do. But he still has the extra clip, the extra 15 rounds in the glove box that he never reaches for. He never even tries to take it out of the car. If this was a premeditated designed murder, a premeditated designed attempt murder, where Mr. Dunn fled Duval County because he knew he murdered someone with the intent and maliciousness to convict someone of that charge, he goes home. He doesn't go to an airport, and you're going to find out he has the ability to fly a plane. He had a pilot's license. He had a reservation at another hotel in St. Augustine. He could have gone somewhere too high, but he went home. He could have never answered the cell phone or talked to the homicide detectives on the phone. He could have hung up and said, "We got to get out of here. They know it's us." And they don't. You know where Michael Dunn goes? When they get home, because it takes 2.5 hours to get home, he goes to his neighbor's house, who's a federal law enforcement officer up north. Spends time down here in the same neighborhood as Michael. Mr. Dunn goes there, and says to him, hey, I need to talk to the police. Would you mind going with me and walk me in there? His friend Ken gets on the phone with 911 to talk to Brevard County. Why? Because Michael Dunn is now safely at home with law enforcement he knows and trusts and is ready to go talk to them. And while this happens, he gets the phone call to come outside. Does he run? Does he flee? Does he come out firing? No. He cooperates. He walks outside with his hands up, gets on the ground, with AR-15s pointed at him nonetheless, and then proceeds to fully cooperate with homicide detectives from the Jacksonville Sheriff's Office. Not only does he fully cooperate, Detective Oliver, one of the homicide detectives who's in the recorded room with Mr. Dunn, even will testify, no signs of deception. And he's been trained, Detective Oliver has training if someone's trying to deceive them or lie to them, and Detective Oliver will tell you, Mr. Dunn showed no signs of deception when telling them what happened the night before, why he shot the gun, why he went to the hotel, and why he came to Jackson. And Mr. Dunn is extremely confident that if you do keep an open mind, do not let sympathy or anger or bias creep into that decision. Be bound by your duty as a juror and bound the jurors next to you to do the same. The facts of this case, with the law, there's only one just and lawful verdict, and that verdict will be not guilty. Thank you.
Thank you very much, Mr. Strolla. The state can call their first witness.
Your Honor, while they're doing that, may I please offer into evidence states, photographs 1 through 160, and counsel has seen this. We also will be using state 170 in evidence that Mr. Strolla has seen and agrees to, and state 168 for now.
Mr. Strolla?
If I can just look real briefly.
Sure. And while you're doing that, the state's witness.
Your Honor, state call Leah Harris.
Leah Harris?
Yes, Your Honor.
Leah Harris, please.
May I move the podium?
Yes, ma'am.